Welcome. This is an exercise on how family trusts in Australia operate. My name is Professor Brett Davies. I'm a barrister and solicitor of the High Court of Australia, and I lecture and my doctoral thesis was on this topic, so I hope you enjoy it. Now, what is a trust? Because this is a threshold question. Only English countries that have come out of England actually have trusts. So in Europe, we don't have trusts. Probably the most common form of trust, the simplest to explain, is when your first child is born, you'll go to the Commonwealth Bank, you will open an account for 100 Australian dollars in trust for that child. That is a trust. Why? Because it has three characteristics. One, you have a trustee, being you, the mum or dad. You have a beneficiary, being the newborn baby, and you have the asset, or I was going to say it's Latin, but it's no longer Latin, corpus, which used to be a Latin term, but now adopted into English. So you've got three things. Years pass, and your child turns 18 years of age, now an adult under Australian law. And that child walks into the Commonwealth Bank and says, I would like, and you have to do it because it's a bare trust, my parents opened a bank account, I'm now 18 years of age, I'd like you to transfer the account from my mum and dad's name into my name. And the bank does so. The trust is now finished. Why? Why is the trust finished? Because the three criteria have now gone. Your trustee and beneficiary are now one of the same people. Therefore, there is no trust relationship. You've still got the asset, the corpus, the $100, hopefully a bit of interest on it over 18 years, but the trust no longer ceases to exist. And that's the very nature of a trust. You've got a trustee who acts in the best interest of the beneficiary, or the object of the trust, which is normally people, and you have a corpus. If you miss any of those, like if the asset has no, or the trust has no asset, well, you don't have a trust. And if the beneficiaries, the trustees are together, you basically don't have a trust relationship. So here's a family discretionary trust. Well, my accountant likes family trusts and another accountant likes discretionary trusts. It's all the same thing. The nature of a trust, of a family trust, is quite a complex beast, and in America we call them sprinkle trusts, but in Australia we call them discretionary trusts, family trusts, or family discretionary trusts. It's the same thing. Now, this is what a trust looks like. We normally draw them as a triangle. We have a trustee. We have an appointor, and we have beneficiaries. Now, let's make this very clear. The appointor is God, and the trustee is a puppet. Now, if you know that, you'll know more than most people. Appointor hires and fires the trustee. So the trustee is just a squashed cabbage leaf. It has no value to the world. God can sack it. So if your worst enemy was the trustee and you're sick of it, well, the appointor, God, can sack the trustee. And that's why in succession planning, we're looking at the appointor. So it could be normally mum and dad as the appointor, and after mum and dad, it will be their children, whoever they select. The trustee might be a company, but you're running business assets in it, or it could be just mum or dad. Now, you've digested that. The appointor's God. Remember that. That's the first thing I want you to remember. The second thing I want you to remember is this. And you're going to be shocked when I say it, and you're going to say it's not right, and you're going to get a bit upset. But you've just got to bear with me for about 30 seconds. A modern family trust in Australia has about 400,000 beneficiaries. What? No, it's just myself and my husband and my children. No, that's not true. I'm going to say it again for the second time. A modern family trust, in fact, pretty much all trusts since the 60s, all family discretionary trusts have about 400,000 beneficiaries. But why? Why would that be the case? Well, let's look at it. So it's not just you and your spouse, your children, your distant relatives, your great-grandparents, your great-great-great-grandparents that died many years ago. It's not all just those people. It's also charities. So we have about 38,000 registered charities in Australia. They're all beneficiaries. If you have a share in, say, Rio Tinto, and if Rio Tinto had 350,000 shareholders, they are also beneficiaries of your family trust. So it's highly likely you're a beneficiary of one of my family trusts, and when you build your new family trust, I'll probably be a beneficiary as well. Who knows? Or one of my distant relatives. It's a very wide class of people, and you want to make it a wide class of people. Why? You're scared, and I'm going to unscare you in a minute. The beneficiaries are these people down here, but these people have no rights. They have no rights to go to the trustee and ask them for any money. And that's how the family discretionary trust operates as far as who is in control of it. So let's now start building a family discretionary trust. I'm going to get the green button. Now, we're on a law firm's website. If you're an accountant, advisor or lawyer building this document for a client, we act directly for your client, and therefore you get the protection afforded. We are the authors of the document. And you'll get a letter in a few minutes as we build this document to confirm that the author of this document, even though you may have built it, is legal consolidated barristers and solicitors. So I could pick data from another document I built, but I'm going to start it from fresh. Our website is designed to educate and train you. There are training videos and hints for most questions. We want to educate you, and you can do that for free. You can do whatever needs to be done, but you can also ring us up too if it's the case that you're still unsure about something. If you come up with a new question, and I've been doing family trustee since 1988, if you come up with a new question, we'll put a new hint in to deal with that. So there's lots of training videos, and there's lots of things which explain how these documents work. The first question: what is the name of my family trust? Now, can you guess the most common name of a family trust in Australia? And it drives the accountants crazy. Can you guess it? Smith Family Trust. You go to a large accounting house, they're going to have 5 or 6 Smith Family Trusts. So it's clear that these naming conventions of trusts are just nicknames. They are not necessarily registered as a company name. They're not necessarily registered as a business name. They're just nicknames. So I don't like Smith Family Trust. There's too many Smith Family Trusts. So I'm going to make it the Jacob Franklin Family Trust. That's it. Now, if you're not sure, there's some hints there. So here's some interesting names for tuna. These are names of trusts we've not been involved in. They're just names that we've picked up. They don't relate to our clients. But I love that the Latin for the sweet life, ex-wife family trust. I caution you not to name your trust anything that will upset the regulators like the Australian Taxation Office. The McScrooge Family Trust I don't think is probably prudent to have. I would go with something vanilla, like a name, or it could be, if you're buying a property in it, you might be buying in the Double Bay, like buying a block of flats in Double Bay in Sydney. I'll call it the Double Bay Family Trust. Now I've got a green tick. Those green ticks are important because this law firm controls the logic flow. We are responsible for this document. If you don't see a green tick, we're not happy. We're happy here. So let's go to next. Now we look at the trustee. This is the squashed cabbage leaf. Remember, the appointer's God and the trustee's a squashed cabbage leaf. And this trust is going to own shares only. Therefore, it's a low risk. So if you're looking at an asset protection strategy, and there are two main purposes of family trusts, they've got an infinite number of purposes, but two main purposes in Australia is either the family trust for asset protection or income streaming. They're the two main ways or two main values that your accountant will recommend a family trust. Asset protection, there are 3 safe harbours. There's your non-working spouse. My wife's a primary school teacher, so she's a safe harbour. I'm a high-risk person because I am a partner in a law firm giving legal advice. That's high risk. If you're a bricklayer, contractor, you're high risk of bankruptcy. If you're a doctor, you're high risk of bankruptcy. If you own an accounting practice, you're high risk of bankruptcy. So anyone operating a business of any nature, whether that business makes a profit or a loss, is high risk of bankruptcy. And therefore, you're not a safe harbour. So in that case, you'd have the woman of substance and the man of straw. The man of straw will have no assets in their name. The other two safe harbours are your self-managed super fund, if you've got one, and your clean skin family trust. And I'm building a clean skin family trust at the moment because I know this family trust will only own shares, which are no risk. So in that instance, I'm not going to expend money building a company. I'm just going to go with a human being. So I shall make myself the trustee. I'll just have one trustee. It's a bit of a risk to have trustees. It's a low risk vehicle because I only own shares, but I'm happy with that. I now go to the appointor. Now, if you're following the man of straw and a woman of substance, then all good things will be with your wife and all bad things with the husband. Now, in this instance, the appointor is a good thing. It's good to be the appointor. And traditionally, you'd put just your wife in. So I'd put my wife in here. But I'm going to also add myself in as the appointer. Oh, hang on, Professor Davies. That's a good thing to have appointers, and normally only your non-working spouse or your safe harbour. The spouse would have that. That's true. But in our family trust deeds, they're drafted so that if you do suffer an insolvency event, you're automatically removed as the appointer. So I will put myself in as an appointer here. And that's two. They're the appointors. Now, the succession planning is done at the appointor level because the trustee is just a squash cabbage leaf. So God is the appointer, and I'll make it the children. So I'll make it the children of my wife and myself. So I'll type in all my children's names, or I would merely type in the children of. If I wasn't married, didn't have children, I'd probably put my wife and my mum and dad in there. So it'd be the children of Brett Kenneth Davies, and my wife's full name, say Susie Smith. Commonly we do that. I would probably correct the spelling of children and the spelling of my name. Now, if I make a mistake, I'll pick it up again in the summary page. But also, if I make a mistake, then just email us. We'll send a voucher so you can update it. So never fear if you put a spelling error in. We just email us directly, and we'll send you a voucher so you can redo it again before you sign the document. So I'm still confused what a backup appointer is. Good. I'm glad that you're still confused because here's some examples of backup appointors. Bubba full name and Bert full name. I'm happily married with children. Well, I'm married, I've got children. My wife says I'm happy, so that's what you do in that situation. Now, this is interesting. My accountant said that I should put the appointer in my will. And Professor Davies said I shouldn't. I can if I want to, but he's recommending I don't. Let me be very clear. Let me be extremely clear. The laws of wills is different to the tax laws of family trusts. They're not related. A will is a grubby little document that can be challenged in your local Supreme Court and completely rewritten. You can change the executors, change beneficiaries under Family Provisions Acts. It's just wide open. In contrast, a family trust can only be challenged by one person, that's your spouse or your partner in the family court. Now, hang on, let me get that right. So you're saying, Professor Davies, that everything that goes into my estate can be challenged because it goes into my will, but everything in the family trust can only be challenged by my spouse. So in a will, there is a vast group of people that can challenge your parents, people you sleep with like a mistress or a wife or a lover or gay partner, and your children and grandchildren and other people in Sydney and notional estates. The class is very wide. So a will is a grubby little document that can be challenged. A family trust can only be challenged by a very small group of people. Well, how does that work? Well, the assets you die with go into your will. Well, the assets in your family trust don't go into your will. All that happens is that the next appointer takes over. You see, family trusts only go for 80 years, and in Adelaide we can get them to go longer. But this is called the law of perpetuity. The law of perpetuity says that trusts can generally only go for 80 years. Now, if you've got this block of flats from Double Bay in Sydney in there, at your death nothing happens. And nothing should happen, because there's capital gains tax and stamp duty if you were to move that block of flats. Massive 4.5% rough stamp duty, transfer duty on that, and you'll be triggering capital gains tax. So you don't want assets to change hands necessarily at the time of your death. So if you die, then your spouse, under the way that the family trust is currently drafted, your spouse will remain as a second appointer. You had two. You had me and my wife. If I die, my wife becomes the sole appointer. Once my wife and myself are dead, then our children automatically, because they're backup appointers, automatically will be the controllers of the trust. Now, this is an important distinction to have in tax. Under Australian tax law, and for asset protection also, it's better to control an asset than to own an asset. Well, what does that mean? Well, the appointer controls the asset but does not own the asset. The person that owns the asset is the trustee of the family trust, who owns the legal ownership, and the equitable or the beneficial owners of those 400,000 odd people. What a great structure. So every year we can make distributions to whoever we want to make to. So this year my wife's on maternity leave, and we'll do a distribution to her. Next year she'll be working full time, and we'll now distribute to our one of our children who's just turned 18 and swanning around university. A few years later, our grandchildren turn 18. Well, we distribute to them $50,000, $60,000 that much, paying much tax. And you can change every single year who gets the loot, who gets the income from that family trust. And that's why it's so beautiful. Now, while accountants call family trust, they're very fixated, and rightfully so, that it's just a mum and dad operation. They don't work that well once you've got 4 or 5 children involved in the appointer clause, because we've got to act unanimously. I call them discretionary trusts when I talk to my fellow brethren or I'm in court, because to me, one of the most beautiful things is the discretionary nature of the trust, that I can make distributions to different people, all those 400,000 people, and change it each year. So distribute to mum one year, dad to the next, then to a wife, or even to a company. So you can see that I do like my family trusts. So the backup appointers are your children. I want my wife as a backup, and then the children. I don't think you should do that. So the children are going to be my wife and myself. I'm now going to go to the set law. King Henry VIII, in the Statute of Uses in 1654, what year was the Statute of Uses? About 1654, the Statute of Uses was passed by King Henry VIII, and it's closed down family discretionary trusts. You couldn't have one anymore. He then went off to fight the French to get the British control back into France, which would have been very good for France, and so that he lost that with his one of his daughters losing Calais. Quite shocking. And while he was fighting the French, some bright accountant came up with an idea of getting around this act, the statute of uses, and all he did was to have a settlor. Now the settlor is a person that puts in 10 Australian dollars into the trust and then says goodbye. So the settlor is just someone, generally a stranger, who hands over $10 and says, that's it. I'm giving you $10, which primes the trust, and I'm off. Now, importantly, of that 400 plus thousands of people that can be beneficiaries, the settlor can never be a beneficiary. And therefore, don't make the beneficiary your son's girlfriend, because he might marry her and we want distributions to her. Don't make it your mum or dad. Settlor's got to be someone you don't like your lawyer, your financial advisor, your accountant. No, just joking, you've got to love your financial advisor, accountant, and lawyer. But it's got to be a stranger, next door neighbour, or one of your professional advisors, because they can never be a beneficiary of your trust. And their children under 18 can never be a beneficiary either. So don't pick settlors who are related to you. Pick strangers. So let's just make my accountant the accountant. The settled sum is $10. Okay, it used to be a farthing or whatever the amount was when King Henry VIII was a young lad. Traditionally, it's just $10. You can make it $15. You can make it $1,000. It doesn't make any difference. $10 is what the Australian Taxation Office seem to accept. Some people will say you need to put a higher amount in. Well, I'm not of that persuasion, but if you are, you can change it. Now let's have a look at the next group of people called the default beneficiaries. Before we do, I'm just all a bit confused. We've got trustee, appointer, backup appointer, settlor, and default beneficiaries. So let's just go through them again. There's the appointer and trustee. The appointer is what? Is the appointer a squash cabbage leaf, or is it God? Correct. The appointer is God. The trustee is just a squash cabbage leaf. If you lose control of the company, if you had a company, God can just sack it. When you die, your wife's then the God. Or you and your wife are gods together. And then upon your wife and yourself dying, if you've made the children the appointers, they're the gods. So that's the trustee appointers. The backup appointers are just the people after you and your wife die. The settlor is someone who cares. It's just one of your next door neighbours or something. Now we've got default beneficiaries. Now, Professor Davies said that there's about 400,000 beneficiaries of a modern family trust. Why have we got named beneficiaries? Because another term for a default beneficiary is a named beneficiary, a default beneficiary, a primary beneficiary. Some law firms have taken out this from their trust deed, and there is some partners in this law firm that would like to do so, but I think it's important to keep it in for two reasons. What you'll be told is that it's a waste of time putting a default beneficiary into your family trust, and I'll tell you why. They're 99% right. So when would you ever use a default beneficiary? Only two times you'll ever need to use a default beneficiary. One is if you forget to distribute the income from the family trust that financial year, which is impossible because you always do your trust distribution minutes before the 30th of June, and you can do your trust distribution on our website. So let's have a look here. You do a family trust annual distribution statement, and you do one every year, and you sign it, so you never ever forget to do a distribution. You must always do the trust distribution before the 30th of June, and if you can, email it to the accountants and there's evidence of that. But if you forget, which I don't think happens very often, but if you forget, then the people that get the income are your default beneficiaries. Okay, well that's hardly even useful putting a default beneficiary in, but you should still do it. Because if you don't, under Section 99A of the Income Tax Assessment Act of 1936, if the trustee hasn't distributed the income, then the trustee is taxed in the trustee's hands at the current highest marginal tax rate. Well, that's not very good. The highest marginal tax rate tends towards 50% over the years, so that's not very good. So that's why we put a default beneficiary in, just in case you forget to do a family trust distribution. The family trust you're building will have a family trust distribution in it as well. It includes everything. So the default beneficiary, I've actually, look, it's done it, this computer system's done it for me. It's actually put in the children of Brett and beautiful young Susie Smith. So the default beneficiaries are the same, in my instance, as the backup appointors. Now there's a second reason why you would put a default beneficiary in. By the time this happens, you will be dead, your wife's dead, and your children are all dead. But what happens is, after the end of 80 years or longer, South Australia doesn't have law of perpetuities, after the 80 years is finished, the trust must vest, V-E-S-T, must vest, which means all the loot, all the assets, the block of flats in Double Bay must now come out of the trust and be distributed. I wouldn't worry too much, you'll be dead, and your kids will be dead, so don't worry too much about what's going to happen in 80 years, and we don't even know. Westfields are a big shopping centre, the American Westfields, Australian Westfields. They're unit trusts structured in the eastern, I think they're Melbourne based, last time I looked. Those unit trusts will vest, and they're worth billions and billions of American dollars. And we think that the law of perpetuities will change, and we've started to lobby one of our Canberra ministers to try and make the law of perpetuity go away. And if it does, your family trustee that you built on our website today will automatically adjust for that. So 2 reasons for a default beneficiary. 1, you forget to make a trust distribution at the end of that financial year, or in 80 years' time, whoever the great-great-grandchildren are or the trustee is, they forget to make a distribution, then it goes to these default beneficiaries. Obviously, all our children are dead, so it'll go to their children or their great-great-grandchildren down the bloodline. So default beneficiaries to me are still worthwhile putting in. Some law firms don't do that. Now, let's have a look. A reference. Reference is just if you're an accountant, lawyer or financial planner, because some of our accountants have got 400 or 500 documents. They want to be able to categorise them. In my case, I'm just I don't have that many documents, so I'll just leave it as family discretionary trust. If I was an accountant or lawyer or financial advisor, I may want my logo to go on. In fact, I probably would. 99% of accountants will want their corporate logo next to our law firm's logo. Select the box to remove Legal Consolidated's logo from the deed. Now, you're going to get a covering letter in a few minutes, which will always have the Legal Consolidated letterhead. It shows that we author the document, that we carry we're responsible for the document. But if you're a law firm, and only if you're a law firm, should you consider taking up our corporate logo. Print, bind and post. I won't need that, but I would like to have a review. So particularly if you're an accountant and you may want this document explained to your client, then tick the box and one of our lawyers will telephone your client and explain how family trusts work. You probably don't need that because you're going to do that yourself. I've got it already, but I can't see lock and build. Where's lock and build gone? I can't see lock and build. Well, let's see what happens if I go next. Lock and build. Now, here it is. This is it. You've done it. You've achieved it. I'm very proud of you. You've got ticks all the way down, which means our law firm is happy with it. And you've got lock and build, which means that we are now happy for you to proceed to purchase the document. But in the summary page, I can have a bit of a look, make sure everything's correct. Yes. The backup appointers, the children. Now, if I want to make an amendment to the spelling or I've changed my mind, I can do that here. No, but I'm happy with all of that. So here we go, lock and build. Now, I'm going to put my credit card details in. And there it is, success. I've now built the document. It normally takes about 30 seconds or so, and let's have a look at what we've built. Let's see, the minutes, the trust deed and the covering letter. You always get a covering letter whenever you build a document on our website. It always comes, every document, even a free stat deck is still coming with a covering letter from us. Now I've got over 3,000 or 4,000 documents here, so let's have a look at how we go here. So these are your documents. These documents are preserved forever. So you can come back in 20 years' time as the accountant or the financial advisor, lawyer, or the mum and dad building this document. You can come back and see the document you built. I can look at the data I put in, but I'm not interested in that. I know the data I put in. I want to see this family discretionary trust. We've worked very hard on it, so let's have a look. So it comes down as a locked PDF. Oh, Professor Davies, it can't be locked. I want to change it. What do you mean locked PDF? I paid for it. I own it. Listen very carefully. This document has been built by our law firm. You cannot change it. We carry the responsibility for this document. You could break the PDF. You could change it. We will not cover you. You've paid a lot of money to this law firm to build this document. You cannot change it. If you want to change it, just email us and we'll send you a voucher to update it. Do not change this document. It covers all the legalities. We, as the law firm, as an Australian law firm, cover this document. Do not change it. And there it is. I said that all our documents start with a covering letter on law firm's letterhead. So there's a trust opinion certificate. Now this is interesting. Normally, when you go to the bank will say, I want a trust opinion certificate. We got one for, I was going to say one for free, but it's part of the cost. So you've actually got the trust opinion certificate, which is handed to the bank, which says there's power to borrow, all those things the banks will want. So normally you'd have to pay $400 or $500 to a law firm for that. It's here. It was part of the documentation we gave you. You might need to get an Australian business number, tax file number, and register for GST. We're not accountants, we're only tax lawyers, so your accountant will help you with that. That's the covering letter. And here's the minutes. Your accountant will want to see those minutes, and it basically establishes, from an Australian taxation office point of view, all those things you need to consider. And then we've got the document. Now, I've removed the legal consolidated logo, because I've decided to do that. But unless you're a lawyer, you should not do that. Otherwise, the legal consolidated logo will be on each and every page, showing we're responsible for it. So here we go. Where's the appointor? Hang on. Who's signing this document? Oh, the trustee signs and the settlor signs. Well, that's interesting. So you see the appointer does not sign or enter into this deed. Upon signing the trust deed, the next door neighbour, a settlor, has paid the $10. So there's a receipt that you received the $10 for the trust known as the Double Bay Family Trust. The appointors are the mum and the dad. The backup appointors are mum and dad's children. Very common. Now I can change that. If a child, such as my 14-year-old son, is playing computer games all day and you want to cut them out of the trust, then you update the backup appointor. There's a trust deed you can do that and cut him out. I'm only joking. If he listens to this, I'm only joking, son. But don't play computer games too much. Now, Professor Davies said there's 400,000 beneficiaries. I don't know. This is a professor in tax law. I mean, is he in touch with what's really happening? Well, I am, because look, beneficiary is the default beneficiary, the trustee, appointer, and backup appointors. Well, that's only 5 or 6 people. But wait, any entity, God knows what that means, subsidy, parent, company, associates, and it goes on and on and on, and all charities, and all schools and universities. So we've got tens of thousands there. Then it says, of that group, any spouse, children, grandchildren of all those people. It's a lot of people. And the reason you make it a lot is these are discretionary trusts, so these people have no rights. What's that? You've got a mistress, your wife doesn't know, and you don't want her to be a beneficiary of the trust. It doesn't work that way. Let's assume your mistress is not a beneficiary of the trust. She probably is, but let's say she's not. In the family court, she will just have this trust overturned and take half the assets. So family courts don't work on this. You could have your spouse removed from this, but still the spouse can still grab the loot. So there's no value in removing or adding a spouse to a family trust deed. In fact, you may want to have, and you will have, all ex-spouses. So if you've got a wife or a husband that you divorced a couple of years ago, they're still a beneficiary of the trust. Because if you have to make a distribution to them, you might be able to make a more tax-effective distribution through this family trust. But this family trust does not require these people to have any assets at all. They have a mere expectancy at most. And it doesn't hurt or hinder whether you have your mistress or your gay partner or your wife or your ex-husband. It doesn't matter. Family court will cut through this anyway. It doesn't matter what you put in the definition. So don't get caught up about your ex-spouse being a beneficiary of this trust. Personal representatives. Wow, that's a big class. So there it is. I promised you there would be 400,000. There's at least 400,000 there. Now, categories. What's all that about? Well, the Australian Taxation Office, and there's a lot of court cases on this, have said that unless you put categories in, you can't stream. And it all came about from Bamford's case. So you can't stream. So if you've got a capital gain and $100,000 worth of income and something else, dividend reputation credits or something, you may want to stream those to different beneficiaries. This allows you to do that in compliance with the Australian Taxation Office latest rulings on it. Now, these trust deeds go out of date because the ATO keep amending things. So every 5, 6, 7 years, you'll need to amend your family trust deed. Now, the vesting date. If it's the case, we follow suit with South Australia and get rid of the rules of perpetuity, which I hope we do, then the vesting date will be infinity. Go until you decide to wind up the trust. Now, the trustee's powers, oh, come on, Professor Davis, I just want the trustee to have the same power of a human being. You know, you can move your arms and buy things and sell things and things. It's not how it works. The courts have said over and over again, it's not enough to say that my trustee, could be a company, could be a human being, it's not enough to say the trustee's got all the power of a human being. You've got to actually put it all in there. So we have put in huge opportunities for people to do whatever they want to do. And you can even distribute to anyone you want for no value, whatever you want to do. While the appointer's there, you're the appointer. You can manipulate these assets as you see fit, subject to your tax laws. And these are all bank friendly, so you can mortgage. The banks like all these things. Wow, goes on and on. Lots of powers. Trustee. Now the trustee, I've forgotten. Trustee and the appointer. Which one's a squash cabbage leaf? Trustee's a squash cabbage leaf. It's a very powerless machine. And here it is. The appointer may replace, add, remove, or appoint a trustee without justification. Goodness gracious. So that's what you want. So God's the appointer. And there's God. And there's the succession planning of God. And there, if you're subject to your insolvency rules. So that's why we now put the man of straw in as appointers with the woman of substance, with the wife. No partnerships. These are all designed to reduce threats of asset protection. Now, this document is signed as a deed, which is very important. I've just reviewed a family trust deed which was not done as a deed. It's not valid. So there's the appointer and the trustee. So we have a family discretionary trust. That's how they work. Let's now say, instead of using the having a very passive group of assets in it, let's build a new family trust, and let's have that family trust operate a business. So I said there's two main reasons of a family trust. income streaming, paying profits and things to different people, streaming the income, and asset protection. This is more of an asset protection play. So what I'm going to do here, I'm going to build a family trust. So here is on our website, so I'll just go into trusts, and I'm going to build a company as trustee of a family trust. So I'm now going to build a company. Now, a company as a trustee of family trust is called a corporate trustee, and this goes through your arguments why you may want to have one. Well, if they were free, everyone would have one, but they cost money, and they cost money to look after. The government fees are quite high in these documents. So this is why you may consider a company and all the rules and regulations informing the company. You talk to your accountant, because if you are running assets in like business assets, you've got to run with a corporate trustee, because what happens, one asset in the trust will take everything down. So if you were to put a business with the block of flats that you've bought in that family trust, and the business goes down, and because the block of flats are in the same family trust, you lose everything. You lose the block of flats as well. So quite often you have 4 or 5 family trusts all holding different assets. In fact, we've just set up an accountant contacted me yesterday, and we set up 2 family trusts for the same business. So one part of the business holds the good assets. So they had a business name, and they then leased it across, like McDonald's leased across the business name to the unsafe family trust. The unsafe family trust has staff, has the lease and things like that. The safe family trust has all the good things in it. So a great opportunity for that. Also consider a unit trustee. So if it's more than mum and dad, consider the unit trust. And lastly, if you do want to look at asset protection, and family trusts are very much part of that, then have a look at this page here and spend 3 or 4 hours going through it with your spouse and just having a look at different ways you can structure your affairs in order to protect yourself. If you need a hand building your family trust deed, all you need to do is telephone us, and we will take you through what you need to do. Enjoy building your family trust deed.